Welcome everyone to this DCI webinar on buyer power and power buyers in cellular SEP licensing. Are there implications for competition and competition law? My name is Bo Hayden, and our mission at the Dynamic Competition Initiative is to place innovation at the center of policymaking for competition and for competitiveness. DCI is co-hosted by UC Berkeley and the European University Institute. We run a number of programs with different stakeholder groups, including policymakers, law and economics professionals, industry representatives, and academics. In particular, we run the Dynamic Competition Policy Lab, the Young Scholars Program, and our industry roundtables, in addition to expert webinars, as we're having here today. Today, we will discuss patent holdout from a monopoly power perspective as a theory of harm for innovation on the technology market. For the first hour, we will start with a presentation of a recent paper on the topic by co-authors Kalyan Dasgupta and David Teese, followed by comments from our distinguished panelists, Pierre Regibald, George Contreras, and Nicolas Petit. For the second hour, we'll have a moderated Q&A and include questions from the audience. So please feel free to submit your questions through the Zoom app. We have a good representation today from the EU, from the US, and the UK, so we have most of the bases covered for the discussion on this topic. Now I would like to introduce our co-authors, Kalyan Dasgupta, who is a director at the Berkeley Research Group, and David Teese, who's professor at UC Berkeley and chairman emeritus at BRG as well. So the floor is yours, Kalyan. Take it away.
Okay. I hope this works. So thanks to Bo for organizing this, and we are delighted that we have the chance to present something that's a little bit unusual and maybe a bit ambitious. And I think we're conscious here that we are swimming a little bit against the tide in that there are sort of established viewpoints on these subjects and how accessible particular kinds of harm are to competition law instruments. But I think nonetheless, it's important to spell out sort of basic theory, and we can only do so as economists. We're not the lawyers here. And so I think our basic theories of harm are sort of rooted in what we think are the correct economics. And what I want to get to straight away is what is our basic thesis here. And I don't want to pretend that there's even consensus, between people that have experience in this space of FRAND licensing and SEPs about the relative importance of hold up and hold out. Those who have read David's papers and the papers that he's co-written with me will know where we stand on those issues. And so the question we really wanted to explore was related to things that we've tackled in previous papers around sort of the bargaining power of SEP implementers. And we certainly have developed the viewpoint in previous papers that there is a significant amount of bargaining power fundamentally stemming from the non-excludability of SEPs and stemming from institutional constraints such as a requirement to be prepared to make FRAND licenses available. And in our past papers, we've explored that from the perspective of how the division of surplus could be potentially inefficiently skewed in the implementer's favor, and you might interpret that inefficient skew as sub-FRAND terms. The point we wanted to explore here is much more about whether, in language that Bo has helpfully used in previous papers, whether this bargaining power is just circumstantial or whether it's systemic. In other words, are we just dealing with certain situations in which the transfer of rents might be skewed, and if there is a policy issue there, it's a FRAND policy issue, or are we dealing with something that rises to the level of a market distortion. And I think our answer is that in some cases, there is certainly the capability for this bargaining power of some implementers to rise to the level of market distortion. The licensing marketplace is certainly a concentrated one, especially when you look at it from the perspective of revenues and profits. You have certain implementers, most notably Apple and possibly Samsung as well. And this has been noted in some court judgments that licenses with such implementers have a significant amount of referential value, especially in an environment in which folks are reluctant to be the first to take a license when the rest of the market isn't licensed. There is a certain benefit to a licensee, a licensor from agreeing licenses with major implementers because of their signaling value, but there's also, again, as some courts have noted, a price to be paid in terms of the benchmark that sets for future licensing. So we do think, and David will elaborate more on this, that there is actually sort of an externality across different licensing situations. And so there's a potential certainly for this to affect implementers across multiple licensing situations, but there also is the potential for this to serve as sort of signaling to the market about the likely position that a particular implementer is going to take, and therefore influencing expectations of what other market participants, other SEP holders might be able to get. And just finishing up on this kind of introduction, but it's an essential one, I feel. I think in our minds, the distinction between a bargaining power situation and monopsony power situation is substantially about whether or not there is a market-wide effect. That's one criteria. The other criteria would be, in a sense, what kinds of producer rents are at risk of being extracted by the bargaining power in question. And I think a useful way to think about it is, if the bargaining power is countervailing, if it offsets seller-side market power, that's one thing. The right way to think about that is indeed sort of a bargaining situation. If, as we think is more likely to be the case, certainly with vertically unintegrated SEP holders, that it's really, whether you want to call them Ricardian rents or innovation quasi-rents that are being extracted, that is a different thing, especially if that happens at a market-wide level. And that has a capability of distorting perhaps significantly the incentive to participate in future standards. It also has a potentially inefficient distortion associated with who gets to participate, because as we discuss, you might move to a situation in which the standardization game is one like it was with GSM in sort of the late 1990s. You have a lot of vertically integrated smartphone manufacturers that are also the big SEP owners. And then there's a different set of potential competitive implications upstream and downstream from that. So I think I think I've already anticipated some of the points before when we talk about monopsony power versus bargaining power. We're aware that there is a view out there that monopsony power, in certainly the classic textbook sense, is vanishingly rare. There's also the view that in output loss or demonstration of an output loss or some other criteria that indicates deadweight loss is required. And there's obviously hesitation at accepting that in a situation where, in effect, the input prices in question are determined through a bargaining interface, there's hesitation accepting the idea of an output loss, and there's a natural tendency to think about this in terms of a transfer of wealth rather than think of it in monopsony terms. But again, as we've said before, I think the question is there a market-wide effect, the types of rents that are being extracted? And in this particular instance, I think there is likely to be an effect, or we think certainly there's a sensitivity of incentives to participate in the marketplace with, there's a sensitivity of that incentive as it relates to the returns that are available. And so, and we've seen that, and we'll get to it with, it's discussed in our paper on the IEEE experiment, where certainly there was an effect of moving to a more prescriptive FRAND policy on incentives to subject oneself to that policy, if you like. We think that, as we've already discussed, there's likely to be an effect on long-term supply, and there is a potential for innovations that might have been supplied, for example, by vertically unintegrated firms that might have been supplied under what you might deem a more competitive buyer-side market structure. So there's certainly a potential for inefficient exclusion of certain competitors from the upstream market. We think here that there are also mechanisms by which there is a resemblance between the decision-making of a monopsonist and the decision-making of a power buyer here. And that resemblance arises because monopsonists, like monopolists, understand the impact of actions at the margin on the prices paid or received from inframarginal suppliers or inframarginal customers. Here, I think there's a recognition that there are spillovers from one licensing situation to another, and that may impact the incentives to undertake or agree to certain licenses, or indeed the terms on which licenses are agreed. So I think mechanically there is a resemblance in that sense, that you might, for example, decide that it's not worth agreeing to pay a FRAND royalty for, if you like, the marginal license, if you think that that's going to influence what other licensees want in the future. So there are trade-offs here which aren't, I'm not going to pretend they're identical to those in the classic monopsony framework, but they are similar in terms of the effect they have on incentives. We also think that the smartphone sector here is actually quite concentrated. Licensees are quite dependent on maybe 3 or 4 major licensors rather are quite dependent on maybe 3 or 4 major licensees as their principal sources of revenue. Certainly, if you're a vertically unintegrated firm, from our experience, there can be a substantial amount of pressure to achieve a license with those implementers, not just for cash flow reasons, but also for, as we've alluded to before, for the referential value it may be able to have in subsequent licensing discussions. So this gets to a point that Bo has helpfully directed us to in one of his past papers. And I think he's made a useful distinction between circumstantial effects and systemic effects. And I think where we are is in the systemic effect world. Likewise, he's got a spectrum of bargaining power, which, and again, this is a useful way of thinking about it, because basically, a distinction between bargaining power that has only a circumstantial effect in a limited situation or a limited number of situations versus bargaining power, if you like, or that has a market-wide and systemic effect, which we would say is effectively monopsony power. So, that's part of the background here. I just wanted to present some indication of what the evidence is in this regard. And I want to say here that it's very, very difficult to determine what a FRAND rate for an individual portfolio is. And those data on what is paid for individual portfolios isn't typically in the public domain. But we do have some useful indications of what the typical aggregate royalty burden is for most smartphone implementers. And I'm going to say that based on my personal experience, this is what's been published in relation to this is about right. And that is basically that the aggregate royalty burden is about 3% to 5% of smartphone revenues. Now, in the past, we've had suggestions, especially in relation to the idea of maximum aggregate royalty burdens, that those might be between 5% and 10%. We think that most of those suggestions are not actually moored in any real study of the value contribution of cellular technology to the end product. And in fact, the genesis of many of those actually was statements made by firms that thought that they would be net licensees and therefore had some kind of interest in capping and suggesting these caps for aggregate royalties. But it's interesting to note that there is a significant gap, even when one uses those stated maximum aggregate royalty burdens as a type of benchmark for what a FRAND rate should be. And in other research, Hayden and Barron have dubbed this the royalty gap, and they've looked at the sources of this royalty gap, and they've tried to attribute what is down to cross-licensing and what is down to unlicensed implementers. And even when you account for those two things, there is still a significant royalty gap of possibly tens of billions of dollars a year. And what that amounts to is basically an indication, or at least in our minds, what that amounts to is an indication that there is certainly some type of depression of royalty rates relative to the benchmark. That, in turn, strengthens the conclusion that what we're looking at is not bargaining power of selected implementers that countervails the market power of SEP holders. But what we instead, at least in our view, the evidence suggests that we are looking at a situation in which royalties are already below FRAND levels in many circumstances, and any kind of further exercise or exceptional exercise of buyer power is really an extraction of quasi-rents and Ricardian rents, and it's likely to adversely impact upstream investment incentives in ways that aren't balanced out by any increase in the profitability or attractiveness of doing more innovation downstream. In the next slide, I think we get to what I already preambled, which is whether we're dealing with a competition problem or basically disputes about money. Now, even with disputes about money, there is a question of whether or not royalty rates agreed in individual circumstances are FRAND. In a previous paper, we spent a great deal of time talking about how there might be useful ways of interpreting FRAND that, if adopted by the courts, would correct what in our view is a growing and significant holdout problem. So we certainly think that reforms to how FRAND rates are viewed and determined, how past use royalties are reckoned with in some of these FRAND rate judgments, which the UK courts certainly have been doing, how issues such as prejudgment interest might help account for some of the economic cost of delay. We've dealt with this extensively in previous papers, and we still think, obviously, that that's certainly useful or essential to get to grips with the problem. Of course, we don't think that there is a guarantee of consistent adoption across different courts and jurisdictions of those measures. We note in this regard that courts in the UK, for example, are perhaps notoriously more keen to get into the mechanics of FRAND rate determination than their counterparts in some other countries. We don't want to suggest that every instance of holdout or bargaining power warrants a competition problem or a competition investigation. That's not what we're getting at here, but certainly we think that there is an impact on market performance and potentially an impact on competition in the future, both upstream in the supply of SEPs and potentially downstream in the smartphone market, from the systemic impact of bargaining power, if you like, exercised by the largest implementers of the power buyers, as we call them in the paper. And we think that that exercise is significantly monopsony-like, that it warrants closer investigation. The legal instrument, I think the way we want to put this is that to us, there seems to be a duck. It walks like one and it quacks like one. Question about the legal instrument through which it can be labeled a duck is one that we leave to the lawyers. But we do note that there are instances in which, for example, buyer power in certain sectors has been the subject of significant investigation by competition authorities. We note that even if the issue is around exploitation of monopsony power, that's not an innocuous issue under European competition law. One may have legitimate concerns about the coherence of exploitative abuse as a theory, as an antitrust theory, but it is something that does exist in European competition law and in the UK. I do want to finish my bit by pointing out that if what we've talked about in terms of the effects on innovation are real, if those effects are real, that shouldn't be treated as some kind of nebulous long-term effect. It's something that actually has very tangible impact in relatively short spaces of time on what consumers are able to experience and consume. And so it's useful to note in this regard that if you just look at, say, a period of about 12 or 13 years between the rollout of edge technology, and then you compare that to HSPA plus, the amount of time that it took to download a YouTube video which had 60 frames per second and 32 MB, that time declined from about 35 minutes to about 1 minute by the time you got to HSPA plus, and that was within a period of about 8 years, if I'm right. And then it declined to about 11 seconds with the advent of LTE. So within a period of a few years, you're seeing a pretty dramatic impact on the consumer experience. I don't want to suggest that the effects that we are talking about will take away all of this innovation, but certainly there is the danger that writing these effects off as something that happens in the long term and something that is too nebulous for us to reckon with now. I think that would be a mistake because we clearly see some tangible evidence that the developments in standardization are very real and have a very real impact on the consumer experience. So that's an important factor in our minds when one discusses the question of output or deadweight losses. There's an understandable tendency to think about those in static or short-term frameworks, but in this particular instance, it feels like the long term we're talking about is really not that remote, and the long-term effects are pretty tangible. So I'm going to skip over a slide and hand over to David and do the navigation for him.
You're muted, David. Yeah.
Hey, Colleen, I have the slides for David. I can handle it. No problem.
Okay, great.
And David, Professor, welcome.
Thank you. Thank you very much. And let me begin by saying that And believe it or not, despite all the focus on these technology markets, I think at one level, it's not fully understood. A lot of the details and the reality where the rubber meets the road, that's not always understood by the economics professional or by lawyers for that matter. And so I think it's instructive to think about what is the overall market circumstance here, and what is the overall ETSI licensing framework. And basically, ETSI was set up with two goals in mind. It's not just to promote the adoption of new technology, but also to promote the development of new technology. And I'm not finished with that slide yet, Bo. You better slow down. There we go. And therefore, to drive that point home, I like to talk about standards development versus standard setting. The minute you talk about standard setting, there's sort of this implicit assumption that the technology falls like manna from heaven, and all we have to do is figure out which are the best technologies to include in the next generation of wireless technologies in the next standard. And that, of course, is not the case. Technology has to get developed, and it gets developed by a lot of players who have in mind getting some kind of reward for the activity. So the standard setting vocabulary belongs to the world of what I call static economics or static competition, and the standards development vocabulary belongs to the world of dynamic competition. And that's indeed, I think, the right perspective we have if we want to have a forward-looking approach. Next slide, please, Bill. So there are some very, very special features associated with the markets we're talking about here. And as I like to explain to my students, patents are not self-enforcing. Even some of the doctoral students takes them a while to figure out that patents are very different from trade secrets. And unlike other bits of property, if it's stolen, you have a chance of securing it back by yourself. If a homeowner or a car owner, if the car owner loses his car, there's some chance that there's recovery mechanisms available to the individual that can be successful. With a patent, you need the court system. The only redress is through the court system, and that obviously impacts the bargaining circumstance. And at least in the United States, after 2006, where court injunctions are incredibly limited and very difficult to secure, and around SEP technologies, it's basically impossible in the US. And the natural consequence of all of that, not surprisingly, is a fair amount of unlicensed use of SEP technologies. And in addition to unlicensed use, I would claim there's likely depressed royalties as well. Next slide, please, Bo. So let's think about some of the special features of this market. First of all, it doesn't require permission. An implementer doesn't need permission from anybody to use patented technology because the patents are published by the patent office, and there's no permission required from the patent office. There's no permission required from the courts. There's no permission required from the developer of the technology, from the patent owner. So you have a very special circumstance here that affects bargaining. There's also uncertainty with respect to validity and infringement. Now, of course, in the context of standards, essential patents, there's less ambiguity, particularly since the implementer will usually declare that their technology is standards compliant. So that narrows the issue with respect to uncertainty, and certainly with respect to a portfolio of patents, the probability that there isn't, at least one or more patents that are valid and infringed is quite low. But nevertheless, the fact that there is ambiguity here enables putative licensees to throw up a lot of dust and say, well, we're not sure these patents are valid and infringed, and that leads to delay in the negotiating process. So we have that issue to deal with as well. And and the other thing that I'd like to point out is, as Kellyanne touched upon, there's this what I call referential value of large implementers. Um, there's not only a reluctance to pay in as much as if the money's on your side of the table, um, why yield it up? But in particular, if larger players are unlicensed, then smaller players are inclined likewise to remain unlicensed and sit and wait to see what's happening. So there is this externality that comes from what I would think of as the reluctance of large players to act with alacrity with respect to licensing. So patent holdout by one player can impact the the sense of urgency around taking a license by other players. And as I indicated earlier, in this context, it's not surprising there is significant unlicensed use. Next slide, please, Bo. And so one way to think about this is that there's a bandwagon phenomena that is relevant here. I say that because we have to remember these are not one-shot licensing negotiations. When a company, when an owner of intellectual property is engaging in licensing, they're doing so, and they have to do so in the context of a program, because ETSI says, look, you cannot discriminate here. So that means you can't treat every potential licensee on an individual ad hoc basis. You have to have a program of licensing. And that means you've got to launch a program, and getting the bandwagon going on that is extremely difficult. And this bandwagon effect, in my view, can confer certainly bargaining power and possibly buying power onto onto the large implementer, potentially some degree of monopsony power onto the large implementers. Now, I'm actually surprised that there hasn't been, maybe I'm just ignorant, but there isn't much literature on this bandwagon effect feature of the licensing market. Economists have written on bandwagon effects with respect to labor markets, but to my knowledge, there's nobody sort of picked it up and looked at it with respect to technology markets. And it means that a large licensee can offer a lump sum cash payment, and it, the owner of the intellectual property is likely to be willing to take a significant discount just in order to get this licensing program rolling. And that's where you get the notion of of course, the early bird discount. But these early bird discounts are often very substantial and often result in, that they never actually get removed. It's very hard if you grant a discount to one to not give a discount to other, even though the courts recognize the need to kickstart a licensing program. So I'd like to see, and Kelly and I are working on this, further work done on this whole question of a bandwagon effect, because at minimum, I think it results in depressed royalties, not just unlicensed use. Next slide, please. So what does the bandwagon effect do? You can think of it as a type of positive network externality that moves the demand curve out. And in factor markets, when buyers tend to be looking over their shoulder at what others are doing, this can result in the focal firm, the focal licensee, essentially having an effect on the market, not just on their own individual transactions. So while the bandwagon effect may not automatically create monopsony, it does sort of amplify concentration tendencies, and it gives the large players influence that is way beyond their size, which, in this particular market context is already considerable. I do note that Harvey Liebenstein, formalized some of this way back in the 50s, and Veblen talked about this as well, but it really hasn't grabbed much attention. I think Schelling talked about it as well in terms of bargaining theory. But I think it's time for the economics profession to dig in and see if there aren't implications for competition policy. And certainly, I think there are implications for the way in which royalties are set and the likelihood that you end up with royalty rates that are below some objective competitive market level. Next slide, please, Bo. As I said, this is definitely true in labor markets where high status employees. I think of UC Berkeley, people at UC Berkeley take lower salaries because it's UC Berkeley. That doesn't become a benchmark for everybody else, but in a licensing context, it could. In political campaigns, an early endorsement by a big name will garner favors from the candidate for the donor. One way that I found amusing to think about this in terms of the referential power of a large player or even theoretically a smaller player is that there's some aspects of it that are not unlike an individual in a theater yelling fire. You can have a market-wide effect, or in that case, a theater-wide effect. Everyone runs for the exit door, and it's only just one person. So particularly if that one person has legitimacy, it affects behavior. So the idea here is there's a network externality that I think is very much under research that's going on the buyer side of the market, not on the seller side. Next slide, please. Maybe that's my last slide, is it, Bill? If it is, then let me just end on that note by saying that really what we have here is not just we have a bundling of signals together with the provision of a license. So there's some information properties associated with a transaction with a large player that haven't been taken into account. And so all of this is just certainly an invitation to dig in deeper and to recognize that we have here a very unusual fact circumstance with SEP licensing, but we also have the world's probably greatest example of technology collaboration. And so this is not something to monkey with. It's the world's greatest experiment in open innovation, and it's a pretty good experiment. And we're talking about fine-tuning it here to make sure that the open innovation model stays alive, and that, as Kalyan said, the alternative is vertical integration. And if we're not providing sufficient rewards for the developers of technology, then what we're likely to see is a collapse of the market, of the licensing market, and a movement towards vertical integration, which, from a competition policy point of view, would probably be an unsatisfactory outcome. So I'll just leave it at that and hope that these comments invite further discussion.
All right, great. Well, thanks a lot, Kalyan and David, for getting us going. I appreciate you citing my work. I need to catch up to David in citation, so this will be very helpful. I know it's a long-term project.
This doesn't count. It's just a verbal cite.
I'm hoping your paper gets distributed widely. So now I'd like to open up for our discussants, and I'd like to welcome Pierre Regibald, who's a reader at the University of Essex, an academic associate at Charles River Associates, and was recently the chief economist at the European Commission for the Director General for Competition. But most importantly, right, Pierre, you did your PhD of economics at UC Berkeley. Go Bears!
Yeah, just a few corrections, actually. I'm now honorary visiting professor at Essex, and I'm now affiliated with the analysis group.
Okay,
Okay.
Oh, then I was okay. That's good. Now I have
Yes,
that straight.
no problem.
But
First,
the most
let me,
important thing still is that you went to Berkeley, right?
yes, no, of course, that's the main thing. So that defined my whole being and existence, of course. Well, I'm going to start with that. Actually, I was just to say, like, I was interested in this paper, and actually, I'm interested in the whole research program that is being undertaken at UC Berkeley. I think is very useful. What I'm going to do here is maybe try to clarify the argument a little bit. And because it's such a messy situation, I think it's very important to be clear and precise. So let's start with holdup. And I'm really talking about holdup, not holdout. What you start with is a fairly traditional bilateral holdup situation. What is the first side of the holdup? The first side of the holdup is the people who developed the standard related technology have already sunk the resources to get the technology before they start the bargaining with the potential users of this technology. Traditional holdup. Now, the holdup on the other side is a little less obvious because, of course, users do not make standard-specific investment before the standard is designed. But they do make investment in technologies that will only be worthwhile if some standard is developed. And given that once it gets involved, there usually is just one standard that is developed, it does put some also at risk of holdup with respect to those, not specific to a standard investment, but specific to existence of a standard investment. So you've got the traditional bilateral holdup. Potentially, this is of relevance for competition policy because holdup means that this is an issue of market power, the difference between ex ante and ex post market power. And you might feel that exploiting ex post market power is not the right thing to do, especially when you look at the feedback incentive on innovation. Fine. Now, it is because partially of the first side of this holdup, the one that is usually emphasized, of the second side of this holdup, sorry, the one that is usually emphasized, that we've had all of this idea of FRAND. You don't want the SEP holders to abuse their exposed power, da-da-dee-da-da-dee-da-da-da. So you impose, say, think of it as an upper limit on what they can charge, okay? But precisely because it's a two-sided problem, it also would then make sense, by the same logic, to impose some lower limits on what the other side is going to pay. Otherwise, you only pay attention to one side of this double-sided holdup and not to both sides of this double-sided holdup. Now, interestingly, if you move into a world where you essentially both have an upper bound and a lower bound, say, on aggregate royalties, that gives us back to the discussion as to what FRAND is. And in this discussion, as an economist, I've said in the past that actually, as a matter of theory, there's only one FRAND rate, and this is the one that would have been chosen ex ante before the investment were made, right? Now, if, as a matter of practice, one says that maybe an approach is to impose an upper bound on royalty and a lower bound on royalty, then essentially it kind of restores the idea that there's some kind of FRAND range. Okay. Now, what about holdout? Holdout is different, and actually David made this fairly clear. Holdout comes from specific kind of features of the intellectual property and also come of insisting on this FRAND concept. Why? Because it's because of the FRAND concept, where nobody knows what FRAND is, frankly. Eventually, it's what's going to be said by the court, if they want to do that. And also because of the uncertain nature, the probabilistic nature of SEPs, that clearly there's a legitimate reason to go to the courts. And those courts can take time, and those litigation processes can be abused. Okay? So if you can get rid of the need, not saying the possibility, but the need for court to eventually tell you what FRAND is, you're already kind of making progress. If you can kind of limit the uncertainty about both the validity, but especially the specificity, the relevance of the intellectual property right, that's the only way you can decrease this holdout issue. Okay? We move to the third issue, which is the issue of what is called monopsony power, but I'd rather call buyer power. Why would I rather call buyer power? Because we have, as I say, things are messy enough. Let's be precise. Monopsony power in economics reflects to a very specific situation when you have posted price. As a buyer, you face an upward sloping supply, and therefore you realize that if you buy more, you're going to have to pay more. Nothing like this exists, of course, when you trade in a knowledge good. So let's get rid of the monopoly thing. Let's just talk about buyer power, which, by the way, has now become the standard term in competition policy as well. So in terms of buyer power, I think we have, and David made that point as well, maybe not in the same way as I will, distinguish between two things. How does this affect the relative bargaining power of a given SEP holder and a given implementers? And how does this affect the relative position of different implementers? Okay. And this distinction is important too, because it also links to the distinction made in the Unwired Planet case by the judge when talking about the non-discrimination clause and saying, well, non-discrimination is not just non-discrimination. It only matters, a matter of competition policy, if it leads to significant distortion downstreams, right? Now let's look at the first aspect, which is the relative bargaining power, and does the fact that, say, Apple is a big implementer increase Apple's bargaining power with respect to a given SEP holders? In general terms, we know that size itself does not necessarily matter, because size means that if you don't agree, you hurt the other one a lot, but you also hurt yourself a lot. You know, there are benchmark cases where size doesn't matter at all, which is why people like Indus and Valeti wrote a number of interesting papers showing situations where actually you can get away from this neutrality result. And that has to do with things like differences in outside option, which might not be something that really would work here, but more generally speaking, in terms of concavity or convexity of the payoff. So if we're going to talk about changes in this relative bargaining power, we have to translate essentially our stories in terms of this concavity or convexity of the payoff. And in that sense, the kind of bandwagon theories that you talked about could be translated in those terms. In terms of those bandwagon theories, those which are, I think, quite realistic and useful, there's a bit of an ambiguity because it depends on how you phrase it. The way you phrased it is that, look, everybody's looking at each other. Should I get a license or not? I'm only going to move if the big guys move first. In that case, clearly, this is a bandwagon effect that increases the bargaining power of the big guys, because you are eager, of course, to reach a deal with them. But there's another thing. If, as also is the case in the FRAND world, since comparative methods are used, the reference is also on the rate that you agree with, not on whether or not you get a license, but on the rate. That actually goes the other way, right? If you know that the rate you're going to agree with is going to be the rate that is going to be adopted by everybody else, you have a lower incentive to settle on a lower rate, right? So what I want to point out is that I do believe in those bandwagon effect. I believe that the both mechanism on the taking a license or not and the reference rates are true mechanisms. They go in opposite direction. It would be interesting to have the kind of, empirical work, like experimental work that you do at Berkeley, look at, what might be the dominant effect. I would agree, just looking at the royalty rates compared to the innovation contribution, that, my prior is that it probably is too much right now power on the implementer side, but that's just a hunch. From that point of view, I think it's important to follow kind of the direction that you have followed in some of the other paper and kind of systematically look at the share of the bargaining surplus, which is appropriated by the two sides. In that sense, actually, this is another variation you could do, that you can look at the share of bargaining surplus once the investment have been committed to, and the share of bargaining surplus before the investment would have been committed to. And that would give you kind of a window as to how far from, a FRAND, an ex-ante situation, the actual exposed bargaining surplus that we look at is, and that actually might be useful. Two more points and then I stop. From a point of view of, from a point of view of competition policy, this influencing the bargaining between the licensee and the licensor, that's going to be hard to deal with. We usually do not condemn buyer power per se, so we could deal with it within a merger context. So if Apple were to move to merge with Samsung, I would not buy the argument that, oh, it's FRAND anyway, it's not going to have any effect on the. No, I would consider the effect of market power. It's going to be hard to consider it beyond this. You have a bit more of an angle, I think, if you look at how the size of Apple impacts the deal that it gets compared to the deal of smaller buyers. So in the horizontal distortions there, because clearly, given that you have things like litigation costs being fixed costs and so on, that does give an advantage to larger buyers. So that would be more kind of the direction in which I would go. And then finally, let me be quite provocative. I've been in this for a long time, about as long as David. And frankly, the progress made, there has been progress, has not been spectacular. I've come to the conclusion personally that I think that looking for what FRAND is counterproductive. If anything, it leads to long delay litigation. I think that it's high time for standard setting organization like ETSI to become a bit less timid. They've always been, the floor on the dance floor saying that, oh, we're just a nice club. We do things that are good for society. You talk, you do it, but we don't want to be involved in any implementation or making the things work in the end. It's time for them to man up, if I want. So because of that, I would recommend having a maximum aggregate royalty, having a minimum aggregate royalty, and no, competition authorities will not bother you about that. What about the minimum royalty? How you implement it? Well, look, you can sue because you infringe a patent, but the value of the standard goes beyond the value of the patent. As David pointed out, there's work done in not only developing the technology but the standard, but in getting the standard. Okay, so you could think of a world where one would assume ownership of that part of the innovation, of the existence of the standard, and therefore could say something as simple as that. What kind of protection would that be? Would be trademark, patent? We can find something that would work and say, look, yes, you can bargain unitarily, but if you want to start implementing this standard now, even by a foot, you've got to pay us ETSI a minimum aggregate royalty that's going to get into some kind of escrow account that's going to be placed so that there's a return on this account. We can have a clearing mechanism between our members later. I think it's high time to consider more drastic departures where the ETSI and others take on more responsibility, including maybe making access to this fund conditional on essentially the test and so on. It's high time to do this. Otherwise, what I predict is that mobile phone will become an obsolete technology before we solve the problem we've been talking about for 40 years. Thank you.
Great. Thanks a lot. There's a lot of good points there, Pierre. You covered a lot of issues we'll talk about later, so we'll come back to these, including some ideas on how to go forward. Always appreciated. So let me now welcome to the floor George Contreras. George is a professor of law at the University of Utah, and before that he was a partner at an international law firm. And he's a very prolific writer. I think it's a battle between him and Nicola to see who can produce the most papers these days. So George, it's good to have you. Welcome.
Great. Thanks so much for the invitation, Bo, and thanks to Callian and David for an interesting and provocative paper that we can discuss today. So I'll try to share my screen. Hopefully, can you see those slides?
Yes.
Yep. Okay, great. So I am not an economist, as most of you know. I'm the simple country lawyer in this party. That being said, I will save the actual legal analysis of the monopsony theory that's presented here, at least under US law, for the discussion section. And in these 10 minutes that I have now, I'm going to offer some suggestions and comments on this paper, qua paper, how this paper could be, I would say improved, others might just say altered, but to make it more compelling for a larger audience. And I have to say, as I read the paper, and I found it a fascinating read, and the thing that really jumped out at me as I read it was that its approach was fairly narrow, and it struck me as a fairly advocacy-focused piece. And by the time then you get to the end on page 36, there is a recommendation that the commission investigate large buyers, but the large buyer in the paper is Apple, right? Mentioned like 5 times more than any other company in the paper for an optimistic holdout in these bilateral smartphone SEP licensing negotiations. That strikes me as quite a narrow focus for what could be a much more broadly applicable theory and discussion. And so my question to the authors is like, what really is the intellectual value of such a narrowly focused paper beyond advocacy purposes? Obviously, if there's litigation involving these companies, then it's clear what the reason is. So if we view this as a case study, I wonder if it is generalizable to other things. So you talk a lot about the ETSI, 3, 4, 5, 6G standards. I call them NG. But the SEPs, those exact same SEPs, are being licensed in markets outside of smartphones in a very different way, in a way that, to me, and just judging by the amount of litigation, could be turning out differently than the smartphone market. I'm also curious what the implications are for other smartphone standards. There are hundreds of standards embodied in any smartphone. We've seen litigation around Wi-Fi. We've seen increasing amounts of litigation around codecs. They are pool licensed, sometimes not. How generalizable are the conclusions of this paper to these other standards? What about buyers other than the one buyer who is named so frequently in this paper? And what about patents other than SEPs? I think that there are some very interesting observations that can come out of this paper, but I think the focus of the paper on this one market segment and this patents that are, licensed only in this segment, in this particular mode, bilateral licensing as opposed to pool licensing, I think it detracts from the potential impact of the paper. So what's the thesis beyond, there's one company who may be misbehaving in the marketplace? That leads to the question of what do you want to get out of this? What's the desired result? As we in the US, courts rarely try to supervise the price bargain directly, right? In the delightfully named case, Cartel versus Blue Shield, in an opinion written by then Judge Breyer. It's clear this sentiment runs throughout U.S. antitrust law. Courts don't attempt to interfere in the actual pricing bargain. They try to restore competition by eliminating the anti-competitive conduct. So what could happen as a result of this commission investigation? Well, fines. We've seen fines are in the headlines quite often with the commission. How does this help the SEP holders? We're talking about very deep pocket companies in this case. How is the situation helped if the commission just fines somebody? Is behavior going to change? If not, maybe it's injunctive relief that the authors are seeking, an order not to hold out. How that would be implemented is a little bit difficult for me to envision. Order somebody to enter into licenses faster, maybe, but we always have the question, what if the license is not FRAND? This is what the implementers argue. Would we prefer that courts fashion licenses and determine rates? Well, that's something that I certainly have written in favor of in other contexts, maybe, but I don't see the authors suggesting that. Or is this just an opportunity for another private right of action in which SEP holders can now bring counterclaims or direct claims against implementers for monetary damages? Is that something that is going to be helpful in the economy and in the market? My intuition is no, although antitrust private damages can be quite lucrative to the parties, especially in jurisdictions like the US, in which they are trebled. I just don't think that more litigation is the answer to the situations that we have. I also take issue with a couple of the factual characterizations in the paper. In particular, the one that we hear repeatedly, that injunctive relief is generally not available to SEP holders. Well, I think, like, clearly in Europe under the Huawei ZTE framework, it is available if a company that is a holdout, as defined in the paper, is shown to be an unwilling licensee. And I think there's a great correspondence between unwillingness and holding out, however we define holding out. And injunctions are being granted all the time, both at the Unified Patent Court and in courts in countries all around the world, including China. I saw China. David mentioned China as a company, I think, where injunctions were less available. They're quite available in China. And even in the US, injunctions remain a threat, both the International Trade Commission and in the courts. Every study that's been out there shows that at least 70% of permanent injunctions are granted to patent holders, not for SEP holders. But why is that? It's because of the SEP holders' contractual commitment to seek monetary compensation for their SEPs. However, in the US, the offsetting balance there is that enhanced damages are available for willful infringement. So the true holdout, if there is a holdout, does face a steep penalty. And I can assure you that in every SEP case in which damages are sought, enhanced damages are sought by the SEP holder, because again, SEPs are notified to the public. Everybody knows that if the patents are valid, they're infringing. There's also statements about implementers, like there just being a significant incentive to hold out. And that's not necessarily accurate either. Most licenses do get signed, and most litigation settles before the point of a judgment. And in the literature, there's this extensive literature arguing that holdup does not exist. And the authors of that literature point to this very fact, that the vast majority of licenses get signed. Maybe they're being signed at rates that are too low, the authors might argue. But I would at least say that there are plenty of incentives to agree to licenses. And then there seem to be repeated assertions that rates are being set below FRAND. There's no compelling evidence that I see that that is the case. FRAND, as we've heard, and I agree, it's hard to figure out what FRAND actually is. But this argument strikes me as a converse of the argument that implementers make, that the rates that they're being charged are above FRAND because of the threat of injunctions. I mean, these are just two sides of the same argument. Each party is simply arguing in its own self-interest. And we don't know what FRAND is until a court or an arbitrator determines it. My final point really is that litigation, which the paper seems to argue should be avoided at all costs, it's a valid piece of the system. It's not an antitrust violation in the US to seek judicial redress for a wrong. Litigation benefits rights holders. It is there precisely in situations, as David mentioned, where self-help is not available. And even, trust me, as a teacher of property law, I can assure you that self-help is frowned upon, if not outright illegal, these days in even real property scenarios in the US. SEP holders do, or at least they should, take enforcement costs into account when they're pricing their rates, just like every other rights holder does. Mortgagees, banks, they price the risk of foreclosure into the cost of every mortgage that they issue. I think that SEP holders either do this, or if not, they're missing a very basic a piece of their pricing strategy. As far as the implementer side, challenging patents, it's not simply a tactic to depress prices. This is a legitimate right that is asserted because as we've seen, and many empirical studies have demonstrated, many asserted SEPs are not essential to the standard, they're not infringed, or they're not even valid. And so challenging those patents is essential to the integrity of the patent system. The Supreme Court in Lear versus Adkins a half a century ago made this very clear. We need potential licensees to be able to challenge the patents that they are being confronted with so that invalid patents are not being licensed. And it's fundamental that a licensee should know that it's only paying for valid patents. The alternative is worse. So what might actually help? I do echo some of Pierre's comments and recommendations. We've both written extensively in this area. One thing that could address some of the issues raised in this paper are more transparency by licensing rates, things like pools, including pools like Avanci that license the exact same SEPs that are at issue in this paper. Undoubtedly, there's litigation over Avanci licensing, but less litigation over the level of the rates. The early bird specials, I think these are fine. I think courts have recognized that these are fine. And if you have a standardized rate, as we've seen in patent pools, standard-related pools for decades, starting with the media pools, DVDs and CDs, and moving on over the years, even large buyers don't have much power to influence those standardized terms. We can also make litigation more efficient. Litigation is not a bad thing, but it is bad when it's inefficient. And I've written plenty about this. Parties could theoretically agree to arbitrate their disputes, as Lord Justice Richard Arnold has repeatedly stated. I have argued that it would be best to do this on a collective basis, sort of like the interpleader action that we have in the US, or the collective rate setting that goes on the copyright side of the IP fence, in which all of these disputes get resolved once and for all by a court with jurisdiction over all of the parties. You can also have third-party rate setting by an independent agency, a WIPO, or somebody like that. And this would all eliminate the number one point of disagreement over the licenses, which is the price. And then if there's a company that refuses to sign a license, we know they're a holdout. Those are the true holdouts. The holdouts aren't the companies who are saying the price that you're offering me is too high, it's not FRAND, and by the way, your patents are invalid. Those are companies who have legitimate concerns over what's being offered. And so I think that these types of modifications and reforms would accelerate licensing and reduce the payment gap, which I completely agree. The time value of money is well understood. I agree that this is a problem, but I think there are other ways to do this and address this other than introducing yet another antitrust cause of action that parties can litigate over. So that is what I've got, and I thank you for your time.
All right. Thanks a lot, George, and thanks for getting up early. I know it's early for you in Utah. You're going to be very productive today. Now I'd like to move over and welcome my colleague Nicolas Petit, who's a professor of competition law at the Department of Law at the European University Institute, and also together with David and myself, co-founders of the Dynamic Competition Initiative. Over to you, Nicolas.
Thank you, Bo. Can you hear me?
Yes.
Very good. I'm very happy to be here with old friends and people that have inspired me, co-authors and discussants. So it's good to be here.
Can I stop you for just a second?
Oh,
exactly. Thanks.
George, can you take down your slides for now? It's good billboard space. Just stop sharing. Very good. All right. Over to you, Nicolas.
Second try. All right. So
take two.
Take two. All right. So as Bo knows, I've been a bit tired of the discussion on the licensing of standard essential patents. It has been a fairly sterile discussion involving essentially revenue sharing disputes between very wealthy private sector organizations. And it's very hard to address that issue objectively with recourse to reason and evidence. There has been no lack of innovation in finding new economic concepts to win this revenue sharing game in the cellular industry. So we have a lot of acronyms that have been thrown on the table: FRAND, SEPs, SSPPU, LTA. I've lost track. And so I was a bit concerned when Bo said, hey, I'd like to invite you to a webinar on FRAND's licensing of SEPs in the context of SDOs. I got worried. And I was relieved when I read the paper of our esteemed colleagues, because rather than coming to this discussion with a new acronym, the paper, I think, engages with that discussion with fairly traditional economic concepts, discussions around buyer power, monopsony, and bargaining or negotiation power. Okay. Now so that was refreshing in a way. Now I'm not an economist, just like George, and I'd like to focus my remarks on 2 points of law and policy. So the first thing I want to do is to discuss the limited legal instruments that exists in US and EU doctrine to address buyer power directly. And the second set of remarks that I'd like to make are about policy arguments that could be deployed as plus factors to move the law away from its conventional reticence to address these issues. So what are the policy justifications that could prompt, incentivize, encourage policymakers to revisit this discussion? All right, so I'm going to do that. So let's start maybe with the questions surrounding the legal regime of buyer power in antitrust law. So I think it's fair to say that buyer power allegations, and allegations mostly of anti-competitive utilization of buyer power, have been extremely rare in US antitrust law. We have cases of cartels of buyers, American Tobacco or other cases. We have soft law instruments, guidelines on joint purchasing or cooperative buying alliances. But this is mostly for what we call coordinated conduct. So these are agreements between buyers to try to reduce the price of certain inputs. In the area of single firm buyer power, which would be Section 2 cases, it's even more rare. I would say there's no straight case of anti-competitive exploitation of buyer power by a single monopsonist. This is like as rare as a pink panther. Of course, the Supreme Court, in very special and isolated cases, has accepted to recognize the, I quote, theoretical connection between monopoly power and monopsony power, but this has not translated into any concrete enforcement initiatives from the agencies or from courts where a plaintiff could have gone. And one of the reasons for this is that, unlike European law, American US antitrust law does not prohibit, through Section 2, the exploitation of market power itself. So pure cases of exploitation of monopsony power without prior anti-competitive conduct, like collusion or exclusion, are insufficient to support a theory of antitrust liability. These facts are not sufficient to allow a plaintiff to make a Section 2 case. Most of the cases that we've seen in US antitrust law involved either a powerful buyer trying to induce suppliers not to sell to competitors. This is the Clore case. Or cases involving a dominant purchaser making excessive orders on the input market to deprive competitors from inputs. This is the Alcoa case. It was one aspect allegation in the famous Alcoa case, very old case. So let me now moved closer to where I am today in Europe. So in European law, the issue is just slightly different. It's just slightly different because we have a legal basis, which is Article 102, which prohibits dominant firms from abusively exploiting their dominant positions, their market power. So we have a legal basis, but there is virtually no case law and no administrative enforcement of that provision against the prices set by a monopolist. There has been lethargic enforcement, and if you're not well versed in EU competition law, the situation is the closest equivalent, the enforcement situation in relation to excessive prices, excessively high or low prices, is the equivalent of the situation we have in the US with enforcement of the Robinson-Patman Act against price discrimination. There's no enforcement. All right, so I did a little bit of digging though, because I wanted to help my good friends who wrote that paper in search of maybe cases that could provide some legal foundation for what they are trying to argue, mostly from an economic standpoint. So there is an old case from 1983, which is the CICCE case, which in French, Pierre will understand this, means the Confédération Internationale du Cinéma and whatever. I can't recall the end of the acronym. Here's another acronym. The case involved a complaint by a trade association of movie producers. And they were complaining to the European agency, before to the French agency, that the French state TV channels were setting licensing fees too low for the public distribution of the films on the channels. So, and they claimed that this was a violation of Article 102, at the time Article 86 of the treaty. And so they were complaining that they were receiving too little money for their creative inputs. Now, there was no question that the French TV channel in 1983 was dominant, and there was no question that the fees were actually quite low on the facts. The European Commission decided to dismiss this case, and the decision to dismiss the case was appealed before the European courts. The European Court whispered or indirectly formulated an abstract standard to think about whether these fees were too low. The court said that the unfairness of the low fees has to be determined by reference to the relationship between the price paid for the licenses of the movies and the economic value of the service, the artistic quality of the movie, the success in the theaters, the TV audience size, the advertising revenue, the license duration. Okay, I'll come back to that in a minute, because I think that's interesting. The court also said that this assessment had to be done on a film-by-film basis. So if you think about the SEP case, the licensing transactions with Apple might be regarded in ways different from the licensing deals with other implementers of cellular patents. Okay, so we have this old French case. Beside this, we have a bunch of UK and Irish cases decided or dealt with by national competition agencies, the OFT at the time in the United Kingdom. And in most of these cases, these complaints of excessively low prices were dismissed. The OFT in an old case concerning, I can't recall, there are a few cases concerning mostly the deals between travel agencies and airlines, or the deals between telecom companies and retailers. And typically the telco or the airline would pay a commission back to the travel agents or the retailers for distribution. These complaints were dismissed, and the agencies held in a few decisions, that it could only be the case that there would be an abuse in exceptional circumstances. So again, the bar is set extremely high for agencies to go against such excessively low prices or low fees with Article 102, abuse of dominant style, antitrust weaponry. Okay, so the bottom line on EU law is that we have almost no cases to support such a theory of liability, and there's extreme enforcement reluctance to take these cases. This actually applies also in the other direction. So this is not just about monopsony power, but it's about monopoly power, indicating that this has nothing to do with the cellular industry. It is a principled approach whereby competition agencies have been reluctant to engage into price regulation / settling revenue disputes between companies large or small. Okay. Now, bear though in mind that one reference point for maybe a future change in attitude in the agencies and courts in Europe would be that the focus must be on whether the licensing fees are excessive in relation to the economic value of the service. So if you think about it in FRAND context, in a SEP context, what you would like to demonstrate, if that is the legal standard indeed, is that the fees would have to be excessively low relative to the value of the licensed technology on the downstream markets, so on the product market, on the service market downstream, right? Okay, and so then the question is, whether you can establish this. Okay, now, so what I want to say here is that a patent holder may say, hey, you're going to end up paying a fee that's so low relative to the money you're generating on the market for the implementing application. All right, that could be the test, but there's no clear guidance about how this test can be operationalized, right? And how do you calculate the economic value of a product? Willingness to pay, that has been tried in some cases. It's not easy. Okay, so one question you could ask yourself if you were trying to be a little bit creative as a lawyer is, to what extent does the FRAND context, the fact that there has been a contractual or quasi-contractual commitment from both licensors and implementers to negotiate within a fair and reasonable range of constraints, does that change the attitude? Should that change the attitude? Could this be a plus factor to incite the agencies to do more in that area? So I think if we rely on the Huawei versus DCI judgment that was mentioned before by the previous speakers, Huawei has said this very abstract thing, but irrelevant one, which is that the FRAND context creates particular circumstances. And it talks about particular circumstances to tolerate a derogation to the hard line against instructing dominant firms to deal with third parties, right? So they say there's particular circumstances, we can flexibilize this and create sort of, semi relaxation of the stringent conditions against duty to deal in antitrust, right? But that's when the courts say that there are particular circumstances, this applies both to refusal to deals, but also refusal to pay on the other side. There's no reason why the particular circumstances established by the FRAND context would only play in favor of the implementers and not in favor of the patent holders. The court made a general statement here. And maybe these particular circumstances could be enough for the court to say, just like I did with IP and SEP front pledged standard essential patents, just like I did for that, I may actually deviate a little bit from my traditional reluctance to do this, right? So that's what we have in the law. No more, no less. Okay, so I'm going to now go to my second point, and I'm going to be much shorter. I want to raise 3 policy reasons which could justify, but again, that's a conservative could, because I don't think that there is any appetite in the agencies today to deal with these issues. So it's a really long shot. Reasons for change in approach, reconsidering the approach, maybe stepping in a little more. Okay, the first one is that antitrust law in the United States and in the European Union has been increasingly interested in labor markets. And in labor markets, the main analytical problem is the problem of monopsony power. So there is, in a way, a certain degree of analytical precedence and investment that is going today in the analysis of monopsony power in labor markets in antitrust. And this could be the basis for a policy coherence argument, which would invite the agencies to leverage these new insights into areas which were untouched until today, such as this discussion. So that's reason number one. Policy argument number two would be the Draghi reports in Europe. So the Draghi report has, if you read between the lines, but not too much between the lines, actually the lines, it's actually sort of common thread through the Draghi report, has a very strong message that returns profits. So innovation is what stimulates technological creation and diffusion. It's extremely clear in the Draghi report. So policymakers have to be attentive in relation to maintaining a sufficient amount of rewards for technology creation and diffusion. And Draghi says, this is inked out very clearly in the Draghi report. Draghi said that property institutions and legal certainty are crucial to achieve that goal of properly remunerating technology creation and diffusion. So there could be an argument after the Draghi report to say that excessively low prices manifest buyer power opportunism that undermines the supplier efficiency, productivity, and innovation. That could be another one. And then there's the third one, and I'm sorry that I'm the one bringing this up because it's become a little bit like an almost tired reference, but there's of course the AI stuff, right? So we are currently discussing in the American courts, but also in the European courts, a gigantic form of holdouts by Gen AI provider on copyrighted material. And this is IP, and this is content, this is invention. And we are certainly today in the middle of maybe the biggest monopsony power discussion we ever had in the technological field. So why not think about holdouts in AI in conjunction with holdouts in the FRAND arena? All right, that's all I wanted to say. Thank you.
All right, thanks everybody. That was very good. Here's what we're going to do. We have about 30 minutes left. We have a few questions in the Q&A. I think we'll hit on those with some of the questions I have prepared. But before that, I'd like to give Colin an opportunity to give a few words. But we can put everybody, Carla, we can spotlight everyone and get everyone up on the page so we can take a look at each other.
Right. So, I mean, I think there's some pretty valid points raised in terms of the focus of the paper, but I do want to point out that we are in a very skewed world. So if you find that there's a disproportionate focus on one company or two companies and one set of standards and one set of users of those standards, that has, I think, a distinct link to the share that those companies have and those standards have in terms of the overall revenue that's available to SEP licensors. This is focused on ETSI standards, which are quite relevant because they're, in our view, the driver of significant amount of the innovation that happens in the smartphone sector, which is a pretty important sector. I also think that probably the majority, maybe the great majority of litigation in the SEP space is around ETSI standards. So there is a reason to kind of focus on this as a particular marketplace, and to focus on the implementers that have by far the highest share of the available revenue. In effect, our benefit are kind of the main sources of licensing revenue for SEP holders. I mean, another pretty good point that was raised was around, well, the terminology, monopsony power and buyer power. I would agree that buyer power is sort of a standard term. I think there's still use in using the term monopsony, because I think, as we pointed out, there is an issue around depressing the price below what we might consider a competitive level and what that entails and the inefficiencies that can result from that. Whereas I would think of buyer power as including the cases where the bargaining power of the buyer is exercised in a countervailing sense, or in a very neutral sense. So, you know, there are the other point in relation to the value that's contributed by the standardized technologies. You know, I have done some work on that, and I think that what evidence we have about aggregate royalties, and I have to say the evidence that's in the public domain in these papers that estimate 3 to 5%, that's very true in my experience, having looked at license information in the context of litigation. That is pretty much about right. I would suggest that where you have an improvement in cellular air interface standards, the data transmission speeds, at least in historically, have been a kind of major driver of why people might want to buy new smartphones and things like that. And I really genuinely think that 3% to 5% probably understates the type of dramatic increase we've seen in those data transmission speeds. I realize now my slides weren't up on the screen when I was speaking about this, but I think when you're talking about 30 minutes to download a YouTube video using the 2002 technology and a minute using the 2011 technology, that is pretty tangible improvement. So the other piece of evidence is, you know, these suggested aggregate benchmark rates of around 8%, 10%. And from what I see, aggregate royalty rates are not close to hitting those levels. So I don't think that, you know, with all due respect, I don't think we're out on a limb in suggesting that rates might actually be a little bit low. In terms of the value contribution of the technology, I think Nicola is spot on. You know, that analytically, that is the issue. From an economic perspective, you know, why are we interested in this issue is because of its potential to depress returns below, significantly below, I mean, the value contribution of the technology. So I'm not suggesting that all of the surplus contributed by a technology should go to the SEP holder, but and I admit this is a very tricky concept. There is some notion in sort of the creation of FRAND that there is a way of sharing that surplus that is consistent with balancing incentives between SEP holders and implementers. Obviously, economically, it's a horribly difficult problem because is there a single unique optimal split of the surplus in all circumstances? You know, who knows? But at least these economic ideas are guidelines that help us in how to think about the problem. So, you know, there is unfortunately a lack of really serious empirical studies on the issue of value contribution. I think that's actually the biggest gap in all of this debate, because even when we are talking about what's a reasonable maximum aggregate royalty rate, what's a reasonable minimum, we don't have an idea of the value, really good idea, solid idea of the value that's being contributed here. There is one paper that had, in draft form, a specification of a model that actually seemed to produce very sensible results, and actually had some interesting insights. And then in the published form, I think they changed the way in which they specified the price variable, and that resulted in some patented features of smartphones having very high potential value contributions, you know, NFC technology, potentially 25%, you know, of the profits of an iPhone. So these models are unfortunately quite sensitive to their specification. These are difficult problems, but there's definitely, I think, from an economics point of view, I'm less willing to comment on the legal situation. There's definitely a lot more that should be done here, because the debate is important and interesting, even though it's been well rehearsed and the positions are well hashed out. I'll stop there.
All right. Oops. Thank you. You can hear me now. Good. We have everyone, put everyone together. No spotlights anymore. That's good. So we'll have a little bit of a chat. I put together a lot of questions, so we're going to be here for another 2 more hours. I hope that's okay. Nicola has his hand up already. That was quick. Nicola, did you have something?
Yeah, I just want to say something quick to dissipate any misunderstanding. I have said that there is no, I know of no case, and I think that there's no case in the EU finding a firm guilty of abuse of a dominant position because, as a buyer, the prices it has been taking have been depressed to an excessively low level. That's what I said. There are lots of cases in which buyer power has been recognized in market definition, at the market definition stages, at the entry barriers cases, that, you know, and so on and so forth. Not has the determinants element of leading to a finding of abuse.
Maybe just a comment on this. If
Yeah.
we look at the mirror image of usual dominance, essentially, how do you get at them? Clearly, I've mentioned merger. There are then abuse of dominance. You could say abuse of buyer power. But what form do they tend to take? They tend to be contractual clauses, right? So if there was some kind of agreement or restrictive clauses imposed by Apple in this licensing agreement or something like that, then you might be able to translate this into the equivalent of an abuse of dominance. Same thing in principle, right? Invalid litigation can be an abuse of dominance. But when you see how reluctant EU law has been to go with this, right? There's a couple of old cases, but where the balance is between the abuse of dominance and the right to use the courts, given the specific feature of the rights talked about here, that direction I just don't see would be worthwhile pursuing.
All right, we have some hands up already. So let me go to George and then to Kalyan.
Great, thanks. So I don't know, I guess the idea is we can pick which question we want to answer. And I think
I haven't gotten to the questions yet, but yeah, go ahead.
okay, well, I'm going to address question 2 because we don't have that much time, and I think this is really part of it. Whether this monopsony theory, again, if we're calling it monopsony, at least in the US, whether that's a coherent, legally actionable theory, I think it's not, for 4 reasons. I mean, first, Nicola nicely went through the US cases on this, of which there are very few. And this fact pattern and the economic effect here really matches none of them. There's only one Supreme Court case on this, Weyerhaeuser, which relates to predatory bidding, right? A buyer with power forcing prices up, not down, forcing them up to drive its competitors out of the market. So that's the complete opposite of what we're talking about here. SEP owners do not compete with one another for the buyers, right? So unlike the cases in the merger context, we get monopsony arguments and cases, and mergers have been rejected as a result of monopsony considerations due primarily to labor considerations. But again, here, SEP owners are not competing with each other like workers. Reducing prices isn't going to force some to take a low price in order to get the business as workers might. So there's really no analog here to the existing cases. The second point is SEP holders have a very big advantage here that others don't in obscenity type cases because they can resort to litigation to get the FRAND rate, right? The power buyers cannot drive rates all the way down to, incrementally above zero. There's a floor on the rate, which is the FRAND rate. And while it's difficult to figure out what the FRAND rate is, it's not zero. And courts have awarded FRAND rates that, are quite handsome and result in the large revenues that the authors have talked about it. So there is a safety gap here. The third point, one which courts recognize and talk about in all of the monopsony cases, is that lower prices in general benefit consumers. Now, there's debate about how much of the input cost savings gets passed through to consumers. That's a factual question. But in general, lower costs are things that we like to see from the consumer standpoint. And then, of course, that brings us to the fourth point, which is the point that David makes, and this is the dynamic competition initiative or institute or whatever it is. So we have to talk about dynamic, considering the dynamic considerations and effects, and this argument that suppressing prices on the buyer side results in reduced innovation and thereby harms the market. I mean, that's a factual question. I guess it's possible, but counterbalanced against that is the increased innovation that occurs on the buyer side as a result of the lower input costs. And if you look at the buyers in this market, look at Apple in particular, who is the one called out dozens of times in this paper. They just announced the iPhone 17 this week, and it seems to have a lot of innovations. And in fact, very few of those relate to the download speed of a video over the cellular network. I mean, I haven't downloaded anything over the cellular network for years, right? We all do that via Wi-Fi. And the biggest innovation in the iPhone 17 is the camera technology, which we haven't talked about at all, but it sounds like it's pretty amazing. And it may induce me to go get a new iPhone as a result. But there is plenty of innovation. The dynamic effect argument applies to both sides, both to the SEP holder side and also to the buyer side, at least in this market. So that's what I think.
Thanks, George. I suppose that most phone manufacturers, if we still call them phones, consider cellular important. Otherwise, they'd offer a product that didn't have it, just with Wi-Fi. But I see your point.
Trademark.
Thanks. Colin.
So I did want to say a couple of things about the about cases and case law and so on. And so one, this might be a UK peculiarity, but there is more appetite here for taking on cases that involve exploitative abuse. Certainly on the monopoly side, there have been a number of excessive pricing cases that have come up in the last 7 or 8 years. That is a bit of an outlier, but I do want to note it. The other point is, there are instances, for example, the grocery sector investigation that happened between 2006 and 2008, where there wasn't a specific allegation of an abuse of dominant position as such. It was practices in, among buyers who were major supermarkets and how they had the potential to distort competition. And some of that did indeed concern these upstream effects and so on. So, it's not, in that sense, it's not unprecedented for a competition authority to have a look, certainly in especially because distribution activities and things like that have become gatekeepers and have become more important and salient in recent times. I think there has been a greater willingness to look at those issues, regardless of whether they fall under sort of the exploitative or exclusionary bucket. So there are kind of market performance issues that have been looked at in that context. I did want to mention that as a sort of point. And I'll stop there.
Thanks, Kaya. If we go back to the outline for just a second, since we have about 15 minutes left, let's see where we can kind of agree or disagree conceptually. And I think we have some level of agreement here as well. We also understand that some things are empirical questions to be asked and to be understood. So let's try to hit it that quickly. So just the very first one, what is patent holdout? I put up a definition here. It's a bit of a combination of things that I have done and others. But do we agree? All of us agree that there is a phenomena of holdout. Is there anyone that disagrees with that, George? You don't have to agree that it's significant, but just agree that it's a phenomena, George.
I mean, I'll say, I mean, I agree that holdout certainly is a possibility, and I'm sure that it occurs. But the one thing with this definition that I would add is that it's holdout when it's clear that the patents that we're talking about are valid and infringed patents. I think a lot of, I mean, I look into cases that I've been involved with. A lot of the allegations of holdup and unwillingness come from implementer desires to like clarify what the patents even are or how they're being infringed, especially not with the companies that are mentioned in the paper who have 1,000 SEPs. Like I'm sure if you've got 1,000, definitely some of them are going to be valid and infringed, but it's the NPEs who have 3. Right. And in some cases, those aren't all valid. So I don't think that's holdup, and I think that's an important thing.
No, but I think that's good. And I think the word in here, deliberate, is to take that into consideration. So there definitely is good faith activity. So that's the issue. There is good faith activity. You shouldn't just pay people because they ask you to. And then there's more bad faith activity. And so,
and in a sense, if we take measures, like I say, possibility of pre-testing, at least for essentiality, doesn't resolve validity really. We at least limit the scope for good faith delay, and it might give us a better idea of whether there actually is much of bad faith delay or not.
Right, and actors sometimes want delay, even though I will argue the temporal dimension of this is problematic, because we don't know what the value is on the market. So there can be different reasons for delaying to learn. All right, quickly then, if I go back, I know I'm self-preferencing now. This is very much an issue, but where do we agree here? This was brought up by Kalyan and David in their presentation. This is an older paper from Nicola and myself, where we had this discussion, and George, everyone brought this up a bit in their comments. So where,
but you know, I'm not sure that that's the right point of departure. I think the distribution of rents that have dynamic effects clearly are a proper issue for competition law.
Right. So
the problem, of course, as in all dynamics, is we're not quite sure what the right benchmark is.
Right. So that's the question, right? So there was an argument in the holdout effort by lots of people that this shouldn't be an antitrust issue and hold up. It should be a patent and contract issue. So the question is now, when does something become a competition issue? In our model, we talk about circumstantial versus systematic, and then there's market failure when it's systemic. Is that theoretically coherent for people? Is this because if we get to this stage, then the rest is empirical. Kalyan.
I mean, for me, it was theoretically consistent because it fit into kind of my mental model, which all started with a monopsony case from 10 years ago in a completely different industry about when you distinguish between, because precisely these issues about a bargaining interface versus a posted price interface were brought up to say that the monopsony power in question was not relevant. And there, it's got me thinking, and I have been thinking about it for a long time. I think there was a useful a roundtable by the OECD about 15 years ago, to which our very good friend Jeff Church contributed. And I think the US submission made a useful distinction. It's about the ability to depress the price below the competitive level. That's what really distinguishes monopsony power from mere bargaining power. And that goes to the types of rents that are being extracted. I do think the circumstantial, you might have circumstantial holdout in a one-off situation. I, as the implementer, am somehow able to favorably negotiate myself to a position where you know, I managed to get a better than FRAND deal, however you might define that. But that doesn't happen every time, and it doesn't have effects on the rest of the market. There aren't externalities on there. I would say where there's sort of a kind of evidence where that there's a systematic problem with the distribution of rents, that's an economic performance problem, which is a competition problem in some sense, because there is actually an impact on who enters upstream and perhaps an impact on subsequent downstream competitors too.
Pierre, you have your hand up. And then George.
Oh, he's on mute.
George, go ahead, and then we'll wait for it. We'll get Pierre.
Or you know you're muted.
Pierre, you're muted. Can you solve it?
I say,
Okay,
I'm sorry,
Sure.
but I must still insist that I did agree with the use of monopolistic competition, despite the fact that Jeff is also a Berkeley graduate and I had him as a student as a TA. No, what matters in economics is the mechanism. Okay, if we start referring to things by words that is not clearly identified with the mechanism, then that's the loss of the use of economics. And monopolistic competition is tied completely, the monopolistic effect, to the use of posted price with upward sloping supply. If you don't have that, don't use the term.
Okay, that's fair enough with the terms. I like to change terms a lot. I'm not a big fan of deadweight loss either. So we can have a lot of term changes, but is this a concept of harm from this perspective in one way or another, George?
Yeah, so the chart, you know, this is a good chart. This is a nice way of representing this different spectra. But I don't think this correlates to the competition law liability. It's kind of orthogonal. And, you know, I think this is the case both with respect to holdout, but also hold up. And I've, you know, written a long paper about why the idea of systemic holdup, it just doesn't matter. Like, why are we arguing about it? You know, it's individual entities who can be liable for violating the antitrust and competition laws in any given case. And is it possible in any particular circumstance? Yes, it doesn't matter whether it's pervasive or not. There can be market failures if there's systemic holdup or holdout, but that's not necessarily a competition law problem, and we shouldn't look to competition law to solve it.
Yeah. So there's the question of, is this a phenomena? Are there different degrees of this phenomena that have different impacts on actors? As an economist, hopefully Pierre will agree with me on this one, that we don't care who gets the distribution. We only, as long as it doesn't affect the size of the pie or the quality of the pie. But is there a point where there is a market failure where it affects that? And then we can decide whether there's competition law remedies for that. Nicola.
Yes, I would not rule out entirely the relevance of the discussion as to whether the phenomenon is marginal or systemic or systematic. I mean, we can use many words to say this, but from an enforcement perspective, you don't want the government to spend resources on issues that are marginal, and you want the government to prioritize issues that are systemic. And competition policy understand that very well. There is a whole lot of work that's done in something that's called priority setting. So in antitrust law systems that are highly administrative, like the European one, priority setting is essential. And agencies will not take cases which involve bilateral deals that parties feel are, you know, wrongly negotiated, and won't spend resources second guessing what ordinary courts of law can address through, you know, very established means of establishing, giving redress to parties victims of marginal violations of the law. So, and unless the agencies want to set a precedent on the account that there is a problem of large magnitude, right? So again, the marginal case will be selected, or a policy instrument will be formulated if the problem reaches a threshold level of harmful effect in the economy. And that threshold level has to be something like deadweight loss or systematic exit of a certain set of firms in the industry. But you need to bring that evidence to the table, otherwise there's no point.
I mean, I've never been one to say that there isn't such a thing as hold up in theory, patent hold up in theory. And certainly we've written about holdouts, we believe that. I think when we did our paper 8 years ago, we talked about a royalty gap that was systematic, but we didn't claim necessarily that there was a systemic failure of people not participating in standards. It was a distribution of rents. Now, it could be that once it gets to the systematic level, you need to take an eye on it a bit more. But then this is an empirical question. Pierre? You're on mute again.
Trying to draw on analogies, and the analogies I'm going to use this time is aftermarkets. After all, holdup problem is an aftermarket problem, right? And how do we treat with aftermarkets? If we're not a die-hard Chicago person, we say, well, okay, we're not going to get you just because there's an aftermarket. We're not going to make you eliminate all switching costs and so on. But we're going to be worried if you have certain clause, like you can only use our own special parts to replace or something like that, right? That's what we do. Now, is there kind of any equivalent here that we could think about? But maybe one thing is, for example, the ability of a SEP owner whose SEP reads on the standard to also be kind of used in another standard, right? That is something that we would frown upon if that was not allowed. Just the same thing as to saying, oh, I read on this standard, so you've got to pay me. If there's another way of fulfilling this part of the standard, you should not have to pay. These would be the kind of restrictions that would be equivalent to the kind of restrictions we've thrown out in aftermarket. And that provides some consistency.
Thanks, Pierre. George?
Just to quickly add as a footnote to Nicolas' comment, that yes, agency prioritization obviously is important. And I would say my taxpayer dollars should support an agency that is going after systemic market failures. But we have private litigation to fill in the gaps. And, our one monopsony case at the Supreme Court was a private litigation case. Lumber manufacturers suing each other, right? So even if the agencies don't care that much, if it's important to somebody in the industry, they'll bring the case and the law will develop.
Very good. I'm going to do this a bit like the McLaughlin group. Some of you Americans that saw that and say that I think everyone agrees with this one, and we'll move on. So the last one here is a little bit about, is this observed in practice? And this will be the last question. A lot of you brought it up. There's been a lot of I've written about it as well, that there's a lot of collective private ordering, different orders of collective private ordering that bring people to the brink, possibly, of trying to capture as much surplus as possible, but not so far that they create a problem for the other side of the market because they both need each other. And so the question would be, how much does the impact of the extent of monopsony power relate to these different aspects of the ecosystem, like the FRAND contract, the ability to adjudicate FRAND disputes, and George brought that up, the collective repeated game nature of open standards, what David brought up, the global nature of standards in different jurisdictions, and of course the Huawei ZTE framework. How does this create some type of way of keeping things in the center versus, or do some of these cause it to get out of balance? David, did you have your hand up?
Yeah, I did it at one point there. And first of all, let me say the comments here are all excellent. George, you pointed out that, hey, listen, injunctive relief is available. It's available in China. It's available wherever. I struggle to understand why there's so much unlicensed use, if that's the case. So yes, it's technically available, maybe in Brazil and places like that, sometimes in Germany, but it's not enough to really have a market-wide effect. That's my sense of things. And so I think there's still a holdout problem. And it goes both to the amount of royalties paid and I think, you know, although it's mainly intuitive, to the rate as well.
Thanks, David. George?
Yeah, actually, I'm glad David mentioned that, because I like don't get, I'm not like a holdout denier here. I agree that this undoubtedly happens. It's an economically rational approach to take. I question whether the focus, the monopsony piece of it is something that I question, though. As, you know, if you look at markets like India, where there have been like historically like 100 different phone manufacturers, none of whom were paying royalties to any SEP holder. It wasn't the big it's not the Apples and Samsungs of the world who weren't paying their royalties in India. It's the small guys flying under the radar screen. It's not necessarily a monopsony story. You know, the way I see it, I think the majority of the holdout is by small guys. This happens in China too. There are probably 100 smartphone makers in China, if not more, and I would suspect very few of them are paying royalties. In fact, it's the big ones who probably do end up paying the royalties because they're operating multinationally. They themselves are patent asserters like Huawei now. So I don't know. Anyway,
I think that's a good balanced thinking. I mean, we talked in my latest paper with Justus about this indemnification effect where people fly under the radar, or maybe people have SEPs and they're too small themselves to go after other people to get their money, and there needs to be, you know, more collective action. There is a lot of collective action, as I write here, but not enough, as David said, to cover everything.
Yeah, and by the way, the big guys, yes, they do pay, but then there's always this period of unlicensed use before they agree to a license, and that always gets sort of severely discounted. So you've got that element at work here. But listen, let me say, since it's almost the end of time here, that look, I found the feedback incredibly valuable, and George, you're right to say our focus is too narrow, and you know that needs to be amended in the next draft. And look, aren't we out of time here, Bo? And perhaps you can
There's professor's privilege, David, so you can finish up.
No, I'm done here. I'm kind of learned that the antitrust law is unlikely to be a useful way to pursue monopsony. I still think there's a bargaining power issue here. I think intuitively that you know, rates are probably below market, but maybe we're right, and we have to move to a different regime. As Pierre is indicated. Pierre, you laid out basically a whole research program for us, so I think we'll all be busy for the next couple of years trying to figure that one out.
I've always loved giving work to other people.
You succeeded.
So there are some questions from the 3 or 4 questions I think out there. I wonder whether we should address them. I mean, I think they've all been addressed in some way or the other, and there's disagreement here about you know, about some of them. So I don't know if you want to have a look at that.
Yeah, we can take so what I can do is we can do overtime. You know, it's like shows nowadays. They have the regular show and then they have overtime. So for all of our guests that have been paying attention, thanks for today, and thanks for listening, and for all of our panelists, thank you so much. We'll answer some of the questions now from the audience. And if those people listening have to leave, that's of course fine with us. So the first one here was a question from Stephen Dorn, asking about how an implementer can even assert buyer power when there's no competitive substitute that exists. And I think that's actually a pretty good question in general, until you really, you know, dig into the SEP context to understand how this really works. I can just give my 2 cents and then hand it over. Is that just because you have to pay doesn't mean you pay what should be paid or in a timely manner. And if you pay less over a very long period of time, that can have a very negative impact for those that are looking for the licensors. Which so the idea that you have to pay, yes, but if it takes forever and it's not enough, it's still problematic. Kalyan?
Yeah, I mean, I think that is the point, that on the reason that the hold-up theory and so on seems so compelling is because of this idea that there are no competitive substitutes. But then as a strategy, there is a substitute in that you can use until someone stops you from using. And so unfortunately, that's something that, you know, is exploitable. As people have said, there's sort of a good faith interest in determining, you know, whether patents are really worth the candle. But there are cases, spectacular cases, you might say, of years of non-payment against folks that have very serious patent portfolios as well. So, you know, I definitely think not paying is almost like a viable substitute in sort of as a strategy.
And it is a bit of the collective private ordering again, where if everyone were to leave or no one was to participate in the standard, then everyone would be harmed. So there's a bit of a push not to get that far. Saket has asked about that there's implementers are disadvantages, especially in developing markets. I think that you know, most of this was about power buyers, bigger buyers, and then of course the influence of those bigger buyers on others, because there is a collective action problem where no one wants to pay until others have paid. But I think the one thing that George said is correct, is that, you know, in smaller actors in developing countries are likely to be under the radar. So while they lack information, which is negative, there is asymmetric information. They're not necessarily targeted, so they have a bit of a indemnification. Anyone else want to add anything to that? George?
On this point, I would just add a small coda, which I haven't heard discussed much, but I have heard people from some of these countries where most of the implementers are not licensed saying that, okay, if I'm the biggest implementer in this country, I take a license and now I'm paying, but all of these other littler guys have a cost advantage over me because the SEP holder doesn't find it worthwhile to go after them to make them pay. And so I think that the SEP holder ought to be obligated to go after these other little guys, because otherwise I'm at a cost disadvantage because I'm the only one paying.
Yeah, no, that's a big issue. In fact,
But-
anytime somebody pays and the other people don't pay is an issue.
But
Definitely for smaller actors.
Well,
you know, in bargaining, you would maybe expect this to be reflected in the rates that the big guy actually agrees to. So in a sense, that would end up, you know, this fixed cost of swing little people that you do it could indirectly end up hurting the SEP holders too.
well, I also just wanted to add that as a related to what Burst said in Unwired Planet, and I thought he was absolutely on the right track about you know, when is non-discrimination really an issue, and he's talking about you know, when it distorts competition. There's also a bit of his judgment where he talks about the actual input price effect. So you also have to really look at whether or not you're really competitively disadvantaged, except very marginally, because your input cost might be something like, you know, for a patent portfolio could be something like 10 or 15 cents a phone, and the other guy is getting it for free, but the other guy is actually not really capable of competing with you in other dimensions. I'm not really sure there's actually an effect in competition because the cost share of the input is extremely small here, realistically, and in my experience, that's the case. You know, when you compare it to the price of a phone, it's pretty small. So I'm not sold on the idea that the smaller implementers are able to effectively compete just because they're under the radar, you know, not to a very significant degree, but it's, I do agree that they are under the radar.
Yeah.
On the point of non-discrimination, something is just a thought that maybe was considering is that you've got the judge interpretation in Unwired Planet. So that means it's not really non-discrimination in a strict sense. It's only if it has really effect on the market structure type of thing. If we were to go back to a much more contractual view, saying it's non-discrimination on the strict sense, right? That actually, if you think that there's too much bargaining power on the implementer side, that would actually go some way to solving that, right? Because with non-discrimination, I, as a SEP holder, are less likely to give you a good deal, right? And you, as an implementer, are less interested in getting a good deal because you're getting the good deal for everybody. So, that would be a strict interpretation of non-discrimination if you believe that right now the system is biased in favor of implementers would be something we can consider.
Thanks, Pierre. Mariana asks basically if this situation is the way it's described, whether we describe it as monopsony or buyer power that creates a systemic effect. Is there a antitrust toolkit that would be brought into this? Or I think we've discussed this a bit, that the antitrust toolkit hasn't been used in this way before, and that so maybe other remedies would be better. That has been discussed. Anyone want to comment, Pierre?
Well, when I was chief economist, I worked very hard at keeping us as far away as possible from SEP cases, especially about, this vertical level type of issue or something like that. Again, I'm not saying antitrust cannot do anything on it as it can do as a backup for any kind of regulation, right? But in extreme cases. There is some reason to intervene because there are some aspects that have to do with market power. As I say, hold up is market power. And if there is buyer power, yes, maybe. But the tools that the position of antitrust authorities on buyer power are ambiguous enough that is not sure that we're ready to intervene in this very difficult market. It's much easier to introduce some buyer power in the labor market than it is in this market, for example.
Mm-hmm.
I mean, I would agree that it's not being used. I think the point of the paper was to consider whether it should be used, not in all circumstances, not to create an antitrust theory or an antitrust abuse called holdout, or indeed symmetrically hold up, but whether there are cases in which there's a market-wide effect that stems from, let's face it, some buyers have, significantly more leverage and significantly more ability for the reasons that David spelled out, the bandwagon effects and so on. And in those circumstances, the point of our paper was to raise the question about whether there's an antitrust sort of antitrust remedy to that. I think economically there's an antitrust-like problem. And then the question is legally and from an agency perspective, what can you do about it? As I said, for me, it walks like a duck and it talks like a duck, but it's very difficult to put the label duck on the thing. And I acknowledge that's a problem.
Yeah, there's been creativity with theories of harm and theories of efficiency as the world changes, right? They need to think this through. George.
Yeah, I would just say if you're someone who likes antitrust type remedies in SEP cases, right, the real action really is around the Section 1, the collective, the LNG world, right, where licensees are allegedly colluding to drive down prices. And there's a very active debate around the competition law and antitrust implications of that. It's just so much harder in the unilateral conduct context because monopolists have a lot more freedom to, at least in the US, a lot more freedom to set prices, whereas competitors don't. And it's much riskier to do this as 2 or 3 competitors than one alleged monopolist with market power.
Thanks, George. One last question from Jim. Jim says it's tough to argue that holdout requires an infringed patent when it requires a court determination which you can't obtain because of holdout. So he's arguing for their a circular problem here, where because of the delay and the cost, that pushing people to do what is considered to be normal inquiry to whether patents are valid or not becomes more difficult than it sounds. Sometimes when on the eBay case, I got a feeling that the Supreme Court didn't understand that the U.S. patent system was actually very time consuming and expensive, for example. Any words of solace for Jim?
You can get a quick verdict in the Western District of Texas.
11 hours.
So I think what you said, George, about things that make remedies that make things quicker. I think Pierre said, paying a certain amount up front. We don't agree maybe what the top number is, but can't we agree on the bottom number? I do think that there's the temporal issue here is more problematic. If you can make somebody whole, but it takes a long time, it's very difficult actually to make somebody whole. All right, well, I think we've created a new feature here. Maybe so next time with DCI we'll have the event, and then we'll have the kind of how do you say, overtime event. Meet the speakers. Everyone comes behind the curtain, right? It's like a backstage pass. But I really appreciate you guys for hanging in there and answering the questions for all the participants. And it was really been a pleasure talking to you. Really great comments. Just a great group of panelists. So I'm going to give you a hand. And even though the others are behind the wall, I'm sure they're giving you a hand as well. Thanks, everyone. And we'll be in touch soon, I hope. Have a good day.
Thank you. Bye-bye.
Take care. Bye-bye.